For today's guest appearance, very excited to introduce attorney Greg Maxwell. Greg joins us from Amicus Settlement Planners. We handle a significant number of law firm sales for contingency fee practices. And in contingency fee practices, which are typically plaintiff side personal injury law firm practices, the payouts are typically earnouts. And Greg leads a company and is part of a company at Amicus Settlement Planners, where we're going to explore the following question today, which is, what tax savings value do structured settlements provide to sellers and buyers of contingency fee law firms? So Greg, before we address that question, love for you to introduce yourself, and thanks so much for joining.
Yeah, no, thank you, Jeremy. Appreciate the opportunity to be here. So our company is called Amicus Settlement Planners. We primarily work with contingency fee-based practices. So that means mostly, plaintiff attorneys. Most of those, about half of those are personal injury, about half are employment, plaintiff employment law firms. And so we do a lot of tax planning for those clients, for those, especially on the employment side, that are receiving taxable damage cases, help them plan for settlement, help them spread out the recovery to reduce the tax bite that they encounter when they receive these settlements. And then we do work with business owners that are selling, and increasingly, law firms like you mentioned, who are trying to sell but don't want to take the tax hit in the year of sale. So there are some things that we can talk about that we'll get into that help with the tax planning.
Terrific. So let me just share with our audience, okay, just a typical sale of a senior attorney-led personal injury law firm. In those sales, you'll see really two flavors for the most part. One is a pure earnout. Okay, that is that selling lawyer of a personal injury law firm presents his practice or her practice to growing PI firm. Growing PI firm then says, okay, we will pay you a portion of the revenues that come in from the clients that are attributable to your firm. So past clients that make referrals come in from your website, your phone number, your referral sources will treat you as a referring attorney, let's say for 5 years. Second flavor is really an add-on to that, which is, okay, we will pay you the earnout basis and we'll pay you an upfront amount. And that upfront amount is typically an advance on accounts receivables based upon the number of open cases that a seller may have at a given time. And so it's good in terms of being able to monetize. In terms of what you were talking about, we'd love to hear more now, is it opens up the seller to significant regular income tax issues.
Absolutely. Yeah. So in the situation you mentioned where there's going to be an earnout, but in the year of sale, there's going to be an initial payout to the seller. That's really where we can come in and really help the seller with their tax issues. So rather than, if we use an example of, say, they're going to get a couple $1 million up front, and then the rest of their compensation is going to be coming down the road as the firm continues to earn money. If the seller doesn't necessarily want to receive all of that $2 million in the current tax year and be taxed at the highest tax rates because of that, we can enter into what we call a structured installment sale, where the buyer, as part of the purchase and sale agreement, agrees to pay whatever portion of that $2 million. Let's say it's 1.5 million of the 2 million. That's part of the upfront fee. They send that, the buyer would send that directly to a company like MetLife or Independent Life. Those are the two main companies that offer these types of arrangements. And then the seller can then come up with a future series of payments. It could be the next 3 years, 5 years, 10 years, the rest of their life, that they receive the payments from that initial portion. So the point of that is to really get them down into the tax bracket that they want to be in, so that they don't have a huge spike in taxes the year they sell their firm, and then the next years they're back down where they want to be. Excuse me. This gives them the opportunity to spread out that recovery, guarantee themselves some income, and keep themselves in a tax bracket that's more comfortable for them.
Terrific. So let's just drill down a little bit more on that, because I think a lot of the personal injury law attorneys are familiar with, okay, if there was a case that settled for $6 million, okay, and resulted in a $2 million fee, right? And then enter into a structured settlement like we're talking about here. What we're talking about in the sales context, which I think is just so fascinating, right, is that if there was that advance on the accounts receivables, or even let's just say it was an upfront payment based upon the brand value of the firm, okay, that the $2 million is paid. Can you just explain? I remember in my tax class, Greg, the 3 T's in taxes: timing, timing, and timing. That if we could just explain that a little bit more on that $1.5 million, like what are we doing with that money that's benefiting the seller when the money would otherwise hit them and they'd be paying significant taxes on it?
Right. So rather than the seller taking that $2 million in the current tax year and being taxed on it, if you structure it the right way and you have it as part of the purchase and sales agreement, then what's happening is the buyer is agreeing to pay the $2 million, and they're agreeing to make future periodic payments to the seller. But then they're assigning the obligation to make those future periodic payments to MetLife or Independent Life. So the buyer is not on the hook for those future periodic payments. They're assigning that obligation to MetLife. And then what the seller receives is an annuity contract from MetLife, for example, that guarantees them those future payments. So they're only taxed on those future payments as they receive them back from MetLife in this example. So they're not taxed on that full $2 million amount in the year of sale.
Terrific. And now, if it's okay, we'll work through a hypo. Okay. So this is an example of something that we see in the marketplace. Let's say, for example, that a 67-year-old owner of a personal injury law firm is regularly bringing into the firm $2 million in legal fees. Okay, strikes a deal with a buyer, and the buyer says, "Okay, we're not going to pay you anything up front. We will treat you as a referring attorney for this hypothetical." Let's say they're all direct cases. Okay, there's no referring attorneys involved. They're direct cases. By the way, would be great. And the deal that the buyer strikes, we're going to pay you a third of the $2 million, assuming that your book continues to perform. And let's say it does. So for 5 years, the buying firm would be paying 1/3 of $2 million. That'd be $667,000 a year that the seller would be getting for 5 years. But seller tells you, Greg, okay, that our family only needs $350,000 a year because I'm 67. I've got other retirement income coming to me and investment income, who knows what. They only need $350 out of the $667. So what say you?
Yeah. So in that situation, what we'd probably do is set up a deferred comp plan with a plan administrator that works with contingency fee-based attorneys. And so what you could essentially do is say, all right, once the law firm hits that, or once they've paid out enough to get to that $350,000 mark that the selling attorney wants every year, that anything above that, rather than paying it to the selling attorney directly, they're going to send it to the deferred comp plan administrator. And then that's in the name of the seller. So that way, that 317, I think that's the right math, that would otherwise go to the seller, would go directly to the deferred comp plan in the name of the seller with the plan administrator. And in the same way as the annuity, they're not taxed on that 317 until they receive it back from the plan administrator in the future. So,
right. And I think the overall message, right, is that whereas buyer is prepared to pay a third of a third, which is great, if the seller is able to defer the taxes on $317,000 in our example over the course of 5 years, right? Let's do the math, $1.5 million in deferred taxes. And if you could just share with us a bit about the beneficiary aspect of this as well, because 67 years old, you never know, God forbid, lawyer could pass away, right? There's a beneficiary aspect to all of this as compared to just getting that money as it's coming in.
Right. So whether it's an annuity or with this deferred comp plan administrator, the selling attorney would name a beneficiary. So if they happen to pass away within the term of the payback, they will just go to whoever they name as beneficiary. So yeah, that's not a problem.
Terrific. Well, Greg, thank you so much. For plaintiff side personal injury law attorneys, structured settlements are not known well enough yet when it comes to succession planning for your practices. Greg, thank you so much. How can people get in touch with you, Greg, if they've got questions about structured settlement planning?
Yeah, no, I appreciate it. You can reach out to us online. Our website is amicusplanners.com, or my last name, Maxwell, at amicusplanners.com. But yeah, happy to chat with you about any of these options, because it can be really, like you say, really powerful tax planning for the selling attorney. And then also, most attorneys like the thought of receiving future payments from a company like MetLife rather than relying on, how the buyers of their firm perform. So it gives them a little comfort that way. So yeah, absolutely. Thanks, Jeremy. I appreciate it.
Wonderful. Thank you so much.